Buenas and Hafa Day, the Committee on Health, Land, Justice, and Culture is now called to order. It is Wednesday, September 21st, 2022. The time is now 8:42. In compliance with open government law, notices for this public hearing was published in the Guam Daily Post on Wednesday, September 14th and Monday, September 19th, and also posted to the Guam Public Notice portal and live streamed via the Guam Legislature's YouTube channel. Notices were also disseminated via email to all senators and main media broadcasting outlets. General rules of conduct include individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. The agenda item that will be heard today is the following. Bill number 312-36 COR, sponsored by Senator Mary Camacho Torres, co-sponsored by Vice Speaker Tina Rose Muña Barnes, Senators Christopher M. Dueñas, Jose Pedo Terlaje, Telena Cruz Nelson, James C. Moylan, V. Anthony Ada, Frank Blas Jr., Joe S. Agustin, Amanda L. Shelton, and Sabina Perez. It's an act to amend sections 40105A of Chapter 40, Title 7 of Guam Code Annotated, relative to expanding necessary protections for victims of abuse to maintain the safety and basic needs of the victim or the minor child or children in common with the defendant. I'd like to acknowledge my colleagues that are here today, Senator Mary Camacho Torres, Senator Teleti Taitigui, and Vice Speaker Tina Rose Muña Barnes. And now to begin our agenda. Bill number 312-36 COR, sponsored by Senator Mary Camacho Torres and co-sponsored by Vice Speaker Tina Rose Muña Barnes, Senators Christopher M. Dueñas, Jose Pedo Terlaje, Telena Cruz Nelson, James C. Moylan, V. Anthony Ada, Frank Blas Jr., Joe S. Agustin, Amanda L. Shelton, Sabina Perez. An act to amend sections 40105A of Chapter 40, Title 7 of Guam Code Annotated, relative to expanding the necessary protections for victims of abuse to maintain the safety and basic needs of the victim or minor child or children in common with the defendant. Before we hear those that have signed up today to provide testimony on the bill, I would like to invite the prime sponsor, Senator Mary C. Torres, to introduce the bill.
Thank you, Madam Chair, and good morning. Good morning, Mr. Camacho, Mr. Summerfleck. Bill number 312-36 COR is an act to amend Section 40105A of Chapter 40, Title 7 of the Guam Code Annotated, relative to expanding necessary protections for victims of abuse to maintain the safety and basic needs of the victim or the minor child or children in common with the defendant. Madam Chair, this measure seeks to advance the economic rights of domestic violence survivors in protection order proceedings. As too many of us are aware, victims are often forced to stay in abusive relationships due to financial constraints or other economic concerns. One tool to help combat this problem is a protection order, which can help provide temporary economic relief. But before I go into the specifics of our local statute, I want to take a moment to briefly discuss the reason I chose to focus on civil protections for this bill, as well as subsequent bills 313 and 314. There are several advantages to civil protection orders. First, the standard of proof is lower than it would be for a criminal procedure. And while criminal cases demand a high level of proof beyond a reasonable doubt, civil protective orders generally require a preponderance of evidence. As a result, expenses in terms of both money and time are often lower than those involved with criminal trials, while still satisfying the demands of procedural due process. Second, in contrast to criminal or other types of legal processes which frequently involve a legal representative to petition the court for relief, individuals can directly petition the court to obtain civil protection orders on their own. Finally, civil protection orders have the potential to offer victims freedom and flexibility when it comes to addressing their individual requirements. For instance, for some victims, the ability to protect themselves from further abuse and violence matters more than seeing their perpetrator behind bars. By issuing orders, the court can provide tailored relief in order to address victims' specific safety needs. That last point is particularly important, Madam Chair, in determining the effectiveness of these orders. According to a 2009 report to the National Institute of Justice, protection orders, when properly drafted and enforced, are effective in eliminating or reducing domestic abuse. Their utility, the report continues, depends on whether they provide the requested relief in specific detail. A high degree of specificity also makes it easier for police officers and other judges to determine later whether the respondent has violated the order. A similar study by the National Center of State Courts found that a major component of the effectiveness of civil protection orders for victims of family violence depends on how specific and comprehensive the orders are. To this end, Bill 312 includes specific language under our protections from abuse statutes to address some of the most basic needs of victims on Guam, such as health and automobile or homeowners insurance, utility services, child support, personal property rights, and other necessary services. And while I have inserted a catch-all provision to allow courts to grant other relief necessary, I am open to any revisions that our panel might have to expand or revise the language in this act. Madam Chair, I realize that a civil protection order will not remedy all ills. Family violence is a long-standing issue plaguing our island, and successful intervention will require a comprehensive approach that includes proper training, enforcement, and community education. Still, a protection order is more than just a piece of paper. For many victims of abuse, protection orders are the most immediate forms of relief. Moreover, through interviews conducted by the National Center of State Courts with women who filed protection orders, a majority of victims felt that civil protection orders were valuable in helping them to regain a sense of well-being. In closing, Madam Chair, I want to thank you for holding this hearing, and I'd also like to thank my 10 co-sponsors for supporting this measure. And I hope we can move this bill forward to help achieve safety and stability for domestic violence survivors. Situas Maasi.
Situas Maasi, Senator Torres. For the record, in addition to stakeholders' invitations to provide feedback, were sent to the following: the Guam Bar Association members, the Guam Coalition Against Sexual Assault and Family Violence and their partners, Department of Public Health and Social Services, the Guam Police Department, Victims Advocates Reaching Out or VARO, Office of the Attorney General, who is here today. We will now accept testimony from those in the panel, beginning with the Office of Attorney General, the Attorney General leaving Camacho. Due to the availability and interest of time, we understand that you have other matters to attend to, so we would like to open the testimony if you want to provide for the other subsequent bills, and if you can read those into the record as you provide testimony.
Thank you, Madam Chair, and Situas Maasi. First, I just want to thank Senator Torres and the rest of the sponsors of this bill. It is very important. It continues the work that you started earlier this year in empowering victims, giving victims access to the courts, and also just recognizing the unique dynamics that occur in these situations. Physical safety is one of the most important parts, but there are other ways of controlling victims in these situations. The wireless cellular phone bill that you introduced that is now law was one example. Utilities, rent, support, those are also key ways that a perpetrator or abuser can continue to exercise control over victims in these situations. We are fully in support of all three bills. We will submit written testimony subsequent to this, but I just wanted to again applaud the efforts to expand and to recognize that victims of criminal sexual assault, victims of stalking, should be able to go in to get the same procedural type of justice that victims of family violence are currently provided. I also want to give credit to the man seated next to me, Attorney Summerfleck, because when we testified in April this year in support of the earlier set of bills, I pointed out that stakeholders had recognized this particular gap, that a victim of sexual assault or a victim of stalking would have to do a civil case, go in under the civil rules of procedure in order to get a temporary restraining order. And sometimes that takes a little bit longer versus the expedited rules that had already been established for family violence. The first suggestion that we would make is one of the silver linings of the pandemic is the ability for victims to call in or to appear via video conference or telephonic means. Oregon's protective order statutes expressly permits victims to request the court allow testimony be received via telephone or via video conference, and I anticipate that Attorney Summerfleck would probably join me in saying that victims would be a lot more willing to participate if they didn't have to worry about parking in the court, getting escorted into the courtroom, and having to face either family abuse, stalking, or sexual assault. So we can provide some suggested language that we have seen from other jurisdictions for the sponsors to consider amending to expressly allow for that. That type of access could probably be used in all three types of protective orders that would be available if these are signed: family violence, sexual assault, as well as stalking. The other suggestion specific to Bill 312 is to expressly identify these as temporary orders of support and alimony or spousal and child support. I know that the orders for custody are expressly identified as being temporary. So if you could expressly identify that so that this is meant to be an immediate measure, immediate relief, but then anticipate that a subsequent proceeding may need to be filed to establish long-term orders. Also along those lines, there are established factors that courts must consider when awarding child support or when setting alimony, and whether we refer to the specific provisions in Title V or Title 19, just giving the court some guidance as to where they can look to establish these base amounts. With respect to Bills 314, we noticed that there was a little bit of a difference in the duration. So it was 5 years for a protective order in a criminal sexual conduct case until the expiration of the sentence, end of probation, or end of parole. But the stalking protective order was only at the end of the order being docketed. So we would recommend just kind of being consistent, and it would be if there's a criminal proceeding, the 5 years would be from the expiration of the latest of sentence, judgment, parole, or probation. And with that, I'm open to any questions, but I'm actually today presenting on the findings of our pilot program for the lethality assessment program. And Senator, 60% of the victims who were interviewed or were screened in, this is a call of domestic violence. The police officers respond, they have questions. If you answer yes to the first 5 questions, you're identified as high risk. If you answer yes to any of the 3 remaining 6, you're identified as high risk as well. 70% of the victims that were screened were identified as high risk. 70% of our victims right now. And 2/3 of them identified that the perpetrator used other means to control who they talked to, where they went. And again, I think that these types of orders will help empower victims to give them the ability to leave a potentially dangerous situation. So I just wanted to share some of the statistics we have that would support all of these laws. Thank you.
Thank you, Attorney General. So if you don't mind, Attorney Summerfleck, I know Attorney General has to leave, so if we can allow the panel to ask questions of him. Okay, great. So, Senator Torres, would you like to ask questions first?
General Camacho, thank you for your testimony, and we look forward to your submission of your testimony as well, the written submission. You brought up a point about the telephone and video appearances as opposed to in person, and do you foresee that I know that that's a practice in Oregon, you mentioned, and also in Washington State, so we can certainly look at how they do that. But in terms of Guam's model, do you foresee the same type of setup as is allowed, for example, DOC and teleconferencing, or did you want to go a step further and allow for non-visual testimony?
I've actually seen courts now that will allow victims to appear via initials in Zoom and no camera on to provide testimony at sentencing hearings, as an example.
Okay.
So that type of accommodation is already being made in the criminal context. And as you pointed out, the standard is a bit different in the civil context, where there's no right of confrontation.
Correct.
So, you know, I do think that victims would prefer, I know that victim safety at the court is always something that comes up. And if we just expressly allow, just for them to ask the court, and the court can weigh whether they believe in-court testimony would be necessary. But I can tell you, my understanding, I have at least 2 instances where the courts allow them to appear via Zoom, just initials, no camera, and also the telephone is another option.
Okay. And since it's ex parte, it's probably feasible in that situation anyways.
Yes, Senator.
Okay. Thank you.
All right, thank you, Senator. So there are a couple questions. Do you see the court having flexibility in amending an order or an agreement if the defendant cannot reasonably provide, for instance, the defendant lost their job or is unable to pay for utility services to comply with the court terms? Is there that flexibility within this law?
And it goes back to the comment about kind of tying it to current guidelines. So the child support guidelines do provide a baseline. Even if you are unemployed or if you are in prison, there is still a child support amount that can be ordered, that a defendant can be paid. So we want to ensure that temporary support is given kind of immediately, but we also need to be able to come back and kind of do, you know, in a typical child support, our child support guidelines, you have to get income information, you have to run a worksheet, you have to determine the custody arrangement, but if the intention of this bill is to have an immediate support provided, and I will tell you, if you talk to Vero, these situations, the victims are having to choose between being homeless and staying with their abuser. And I understand, Senator Torres, that's kind of what you're trying to address, is if we have an order that a plaintiff can stay in the house, we don't want the perpetrator to move out and now is not going to pay anything, not going to give any child support, not going to give any documentation to potentially move these utilities. So if we tie it to the existing standards, the court would have the flexibility and guidelines that it already probably has to implement to establish baseline child support amounts and then to modify it at a subsequent hearing.
Okay, thank you. And then as far as now, what are the penalties for violations of orders or agreements?
I believe that these bills make it a misdemeanor offense to violate the protective order. There are other criminal offenses, and Attorney Summerfleck raised the potential issue with the contempt proceedings, and then the separate offense of violation of a court order, and just needed to be more aware of it, because I believe there might be a case where it's double jeopardy to hold a respondent in contempt of court who is incarcerated may affect our ability to prosecute that individual for violation of a court order subsequent to the contempt proceeding.
Okay, so what you're saying is that, so what happens now? Can you just clarify that again?
If you are
they don't
found to have
comply?
violated a protective order, the court itself has the ability, well, they can hold them in contempt, which is one avenue, but the penalty that's expressly provided for is it's a misdemeanor offense, and it gets up to a year in jail and a $1,000 fine.
So that's the current,
That's correct, under the current language.
okay. Oh, yes. Attorney Summerfleck.
That if there's a contempt finding with a penalty in a civil action, that can engage double jeopardy in a criminal proceeding. So for example, in the civil world, what we do, if someone violates a court order, we file with the court an action for contempt, saying this individual violated the court order. Now we can seek 2 forms of remedies. One, we can seek a remedy that tries to help them understand that they need to follow the court order, or we can go straight to a punitive remedy, which is straight into incarceration. What we've done in our office is we seek not the punitive, but what we seek is get your behavior in line. So for example, recently we've got a couple of findings of contempt with 50 days suspended, and stays suspended as long as they follow the court order. If they then violate that and commit another act of violence, then the 50 days automatically kicks in. Now, could they at the same time be charged criminally for that violation of court order? I would think so, because the initial order was held in abeyance based upon their behavior. Oftentimes, courts put penalties in place and say, this is what happens if you don't follow my order. And then if they don't follow the order, the sanctions then engage. If, on the other hand, we go on the punitive end and we say we want him confined for 50 days based upon this act of contempt and based upon the violation of this court's order, double jeopardy would engage in the criminal proceeding. And there's a court case to that effect. People of Guam versus Rudolph Torres, 2008, Guam 26. This might be a good decision to look at for you all if we're looking at how we enforce our court orders. One of the suggestions that was made by the Attorney General's office back in that time was that when an action is filed for contempt, the AG's office be notified. The court, of course, said, well, that's nice, but, you know, that's the legislative's role, not our role. So the issue of violation of court's orders has a twofold approach. There's one, the criminal approach, and then there's also the civil approach. Oftentimes, civil is much quicker. When I file my paperwork, ordinarily, I receive an answer from the court the day I file it. I get a temporary protective order immediately, you know, within that same day. Then we appear in court 10 days later, and we argue whether that temporary protective order should be made permanent. Now, if we file civilly, then what we would file is what's called a civil restraining order. We still can seek a temporary order within 10 days, but it's a longer process. And if I might jump forward a little bit, this is why this bill regarding protective orders for sexual assault is so important in our community. Because there is no family violence ordinarily in a sexual assault. There may be in occasions. Today we're working on one where it's one family member sexually assaulting another family member, and we're safe proceeding forward in the protective order setting. But for example, if there is no familial relationship, if they had no relationship prior to that, the remedy we would seek would be a civil restraining order, just like you would seek against a business encroaching on your property. Now, the drawback to that, and the reason I'm so pleased that Attorney General Camacho has brought forward this legislation, and thank you very much, Senator Torres, as well, is because we can't do anything. For example, if a doctor mistreats a patient, I can't get a protective order. I need to file a civil case and seek an injunction, which then raises the question, can that victim later on sue that individual civilly? And my assessment of the law is no, because we've taken their shot at this. They've had their case based upon these facts and circumstances. They've gotten an injunctive relief, but they're barred from seeking damages because you need to file a second lawsuit based upon the same fact pattern. So the key of the protective order is it is not a civil action. I'm not filing in a civil case seeking injunctive relief. I'm filing a protective order, which does not engage res judicata because my relief that I'm seeking is different than I were if I were filing a civil order. This may sound legalese and theoretical. I can tell you it's not theoretical at all. The process hits us on a regular basis where we will say to victims, if you're thinking you want to sue them later on, you shouldn't do this. because you will be barred later on from suing them for money damages. Now, there have been cases where I don't care, he doesn't have a pot to piss in, so I don't care about seeking money damages, I just want him to stay away from me. In which case, we have filed civil injunctive proceedings. But in each one of those cases, we need to caution the victim that if we file this, you're going to be barred from any time in the future ever suing them civilly. So that's why this legislation regarding sexual assault protective orders, in my mind's eye, is key to our community. You know, I can't support bills, I can't speak against bills, otherwise I cross over to lobbying. So what I'm attempting to do here in my little soliloquy is educate you all about what we see in the community.
Thank you, Attorney Summerfield. I know that's perfect testimony for the next bill, but we're still on the bill 312. So I appreciate, though, I know they interconnect.
I understand. They
yeah.
even started jumping, so I followed along with them.
Okay. All right. Sorry, Attorney Camacho, did you have something you wanted to add?
No, I think this is the kind of discussion that we see happening, and again, it just shows how important all the series of bills would be.
Okay, great. So I would like to open the floor to my colleague, Senator Tello-Taitigui, for questions.
Thank you, Madam Chair. Good afternoon, gentlemen. Thank you so much for being here and providing insight. Thank you, Attorney Summerflex. Answered a lot of the questions I had, but there is one I have particularly with regards to Bill 312. At the beginning of where it basically says relief, the provision in 7 GCA, section 415 reads, the court shall be empowered to grant protection by appropriate order or approve any consent agreement to bring the abuse of a plaintiff or minor, which are not limited to but may include. Okay, this is a section in 415 that speaks at the beginning of the legislation, Bill 312. So with that section that says which are not limited to but may include, and then it has a list of all those things. So recognizing the current law allows the court to issue a protection order which are not limited to, those provided in section 4105, has the local court system attempted at all in the past to extend protection orders to include the basic needs of victims such as medical insurance, home utilities, transportation? I guess it's the Attorney General or Mr. Summerfleck.
What I would opine to you is the court does have that power
Right.
not to make money judgment orders, to exclude the individual from the house, to provide exclusive possession of a vehicle. Where this bill goes much farther is it covers the financial aspect. What good is the house if he doesn't pay the mortgage and you're going to get evicted?
Right.
What good is the car if he doesn't pay the car and it's repossessed?
But the current law, it says, which are not limited to but may include, and it has a list down it, and so it doesn't stop the court from including the basic needs for a victim then, in the current law.
It doesn't exclude the court from doing it.
Okay.
But one of the things that we look at as lawyers is we try and figure out what your intent was when you passed these laws. What did the legislature intend for us as the court to do when it created this law? By adding what you've added in Bill 312,
Or 312.
you showed your intent. You said that it's the legislature's intent that these victims receive more than just a protective order, but receive a means of survival. I've worked both sides of the fence on this. I've represented perpetrators and I've represented hundreds and hundreds of victims. I can tell you, most of the cases that I deal with, there's a lot of tit for tat. Oh, you got a protective order against me? I'll teach you. I'm not going to pay the car anymore. I'm not going to pay the phone anymore. And the phone's under your name. So all of a sudden, he's got the phone, her credit's going down the sewer, and they can't break the contract unless they pay off. That's the meaning, that was the beautiful thing about the legislation that was recently passed. This has been a major hurdle for a lot of victims who are just getting by. They don't, well, I won't say they don't. I would say a large majority of the victims depend upon the perpetrator. And I look at these protective orders literally as individuals jumping off a cliff. They're hoping that the rope, perhaps if they're jumping with a rope or bungee jumping on an old rope, hopefully the rope will hold. But oftentimes, if they don't have the support, if everything in their life disappears, they can't pay their mortgage, they can't pay their car, they're in a losing streak. And who's there saying, I'm working, I've got money, come back and I'll pay off the house and I'll pay the car, and oh, by the way, I'll never hurt you again. I don't know how many cases I've heard that promise, that I've gone back into court again and again, seeking protective orders, seeking violations of protective orders. So I think the key aspect of this legislation is it shows an intent on the legislature, which is the intent of the people of Guam, to ensure that these victims not only have protective orders, but have a means of survival without their perpetrator. And yes, the prior law, I've argued everything you're saying. I've also hit the wall on it. You know, whereas here with this legislation behind me, I've now got the intent of the people of Guam that these victims should be supported. And I don't make light of this. Oftentimes, a lot of issues in the court system is trying to interpret what your intent is. And that's where this law shows your intent. It says these victims do need to have support. You know, it's not just Summerflex saying she needs a car. It's you all saying she needs transportation. It's you all saying the mortgage needs to be paid. A lot more power from you than from me.
Okay, thank you so much
And
for
I'll
that.
just, if I could,
Yeah,
Senator,
sure.
add the dynamic that Senator Torres brought up and who's filing for these. So Guam Legal Services does a great job, but you have to qualify for those services in order to have an entity such as Legal Services represent you. A lot of the middle class can't afford an attorney, and they don't qualify for legal services. So that's why the court has designed these self-help kiosks. And when you're a victim of domestic violence and you're going to fill out a form, you're not reading the statute. You're not thinking about everything that you could possibly ask for. You're in an abusive relationship and you're trying to get an order for them to stop hurting you. So what this legislation does, it'll now allow for the court to have forms for a victim who may never have thought about documentation, who may never have thought about asking for utilities to be paid. And now it's the victim asking the court, instead of the court having to kind of on the fly at a hearing when they have two unrepresented parties in a very heated situation. So I think this will really, in terms of empowering and giving access to more victims, that's exactly what the expressly providing for it would do.
Okay. Thank you for that explanation. I appreciate it. The other one, with regard, since I have you here, Attorney General, is with regards to 313. There was a question here. Should the victim be a minor and reside with the respondent or alleged perpetrator? How will temporary care to include shelter and support needed be identified in order to assist victims toward recovery?
I'm sorry, Senator, the question, I'm sorry
Should
about the
the
question.
victim, this is on Bill 313, since you're
Yes,
talking
yes.
about all three. Should the victim be a minor? If the victim is a minor and resides with the perpetrator, how will temporary care to include shelter and support needed be identified in order to assist victims toward recovery?
I think, if I can.
Yeah.
I think that the focus here is if the minor is a victim, unless both parents are perpetrators, which is very rare, that support would be for the parent who has custody of that minor when we exclude the perpetrator. So for example,
But if they're both, then they are sent.
if they're both, then the child is going to be in protective
Protective
services.
custody.
Right.
Services, yeah.
Then public health would get involved and,
Great,
and
that's
CPS would be
okay.
engaged.
Well, but that's rare. It does happen.
Yeah.
More commonly, it's one part of the family that is sexually abusing the minor. And when the other parent finds out about it, that's when everything starts rolling.
Okay. Thank you for that. I have no more questions. I appreciate your response. And, you know, it's obvious. It just boils down to making it clear in the courts exactly what the intention is. And that's what this law is going to spell out for them. It's unfortunate these, the judges that look at this, you know, don't understand that there needs shelter for the individual. A person needs to live every day, you know, and not construe this anything but to protect the individual as well as provide them a home, transportation, medical insurance, et cetera, down the line. So I'm just, I guess we have to spell it out for the courts to do that. And since I have you, Attorney General, you're going to be leaving soon. Again, I just want to make it for the record again. I've requested since January of this year a response to a letter regarding the Port Authority, and I'm still waiting for that. It's now September. So if just bringing that to your attention again, I think Shannon Taitano, one of your attorneys, is looking into that. I appreciate if you can provide me my response to that.
Thank you, Senator.
Thank you.
Thank you, Senator Tadegui. Vice Speaker Tina Mooney-Barnes, do you have any questions for the Attorney General?
Situas Masi, Madam Chair and Manana Situas, thank you to both you, Attorney Camacho and Attorney Weisenberger. Summerfleck, Daniel Summerfleck. I just want to say that when I was asked to co-sponsor this bill, having been at the Public Defender's Office for more than 15 years, literally believing in my heart that the protections and safety would be there for the victims, we now know, as time goes on, that bringing the end to abuse has to start with us, and knowing that as policymakers, we need to make sure that those provisions of safety and protections are safeguarded. And I wholeheartedly ask to be co-sponsor for this because I believe that there wasn't enough. And like you said, sometimes the direction has to come from the body that creates the policy for the executive branch and the judicial branch to execute or to determine. And I guess with Bill 312, 313, and 314, though they all talk about provisions, is how do you have a catch-all provision to make sure that the safety mechanism is there? And we have seen too many times what happens in relationships and why the victims don't leave. I know that right now, as we see today, several cases that are high-profile cases where the victims couldn't even take their children away from incidents that were happening in the home front. And now, if this comes in play, sure, the intent of this GCA was to bring about the cessation of the abuse of for the plaintiff and the minor children. But how do we bring it to end when we don't clarify it? This says shall. Am I correct? This brings it clearly stating that this is what we want to do. We want to protect the victim. Am I right?
Yes.
Yeah. So I want to say thank you. I know that both of you have been in I guess, being attorneys for many years, many decades for you, Mr. Summerfleck, and this should have been done long time ago, and I appreciate you being here, knowing that this will help the victims as they get their cases facilitated to make sure that they're protected. So I want to thank you both for, I would assume, to support the efforts of what Senator Torres has brought to the forefront. So thank you. Thank you, Madam Chair.
Ms. Masi, Vice Speaker. And so, yes, thank you for your testimony. We know, knowing that financial abuse is one of the most powerful methods of keeping a victim trapped in an abusive relationship. Research shows that victims are often too concerned about their ability to provide financially for themselves and their children to end the relationship. Plus, financial insecurity is one of the top reasons women return to an abusive partner. So we do appreciate the sponsor of this bill in addressing this very heavy issue. And so I do, actually, Senator Tadegui has one more question.
Thank you. I always like to make for the record that the fiscal note that was provided for these legislations to be read into the record, and I'm just going to read the last paragraph. Although this bill seems administrative in nature, correspondence with the judiciary of Guam indicates that a minuscule fiscal impact may be felt on operations. The judiciary assumes that an additional clerk may be needed upon adoption and implementation of this bill. Based on the information provided by the judiciary, the total estimated fiscal, Oh, it does go into 313. Yeah. Yeah, and
Sorry,
then
Senator Tadegui, yeah, that's for the
well,
subsequent bill.
because
Yeah.
I know that he's
okay.
leaving, I know you won't be here for the other bills as we go into the, because you have another appointment. So just at the end, Madam Chair, if I can just end this one, it says, combined with the legislative proposed bill number 3136 core is 55,564. Of this amount, 28,595 will be from the personal services, 21,969 from benefits, and 5,000 for equipment and supplies. So I just wanted to put that in for the record, Madam Chair, and since the Attorney General is here, it's always important to hear these comments. I don't know if you have seen the fiscal notes for them, but it's important to know. Thank you.
All right, thank you. Thank you for that. So I'd like to offer the floor to the sponsor of the bill, Senator Mary Camacho Torres, for any closing statements or questions.
Again, I want to express my gratitude to both of you for taking the time to come here. I understand there is a joint conference with the District Court and the Pacific Judicial Conference, which is occupying a lot of the attorneys' and judges' times today. But so I appreciate that you took the time and effort to come here. But more importantly, I want to thank you for also bringing this critical issue to light, the protective order problems for sexual assault victims, and which was a result of the three bills earlier, 242, 243, and 244. But more importantly, it's your practical explanation that sheds light on what we need to do as policymakers to fix those gaps that we see in current statute. We understand that under current law, as you pointed out, Mr. Summerfleck, the court is empowered to grant protections by appropriate order. But the importance here is that almost all U.S. jurisdictions have found that providing specific statutory authority to economic relief was necessary to prevent any further challenges for victims down the road. And with that, I just want to encourage my co-sponsors, to continue to support this bill so that we can have this and the other bills become public law and immediate relief be afforded to the victims of sexual assault and stalking. And with that, Madam Chair, I thank you again. Insidious Maasi.
Thank you, Senator Torres. There being no additional individuals to present testimony on Bill 312-36, this bill is duly heard. The committee will remain open for submission of additional written testimonies for the next 10 working days following this hearing. which is October 4th. Testimony can be sent via email to Senator terlajeguam@gmail.com or hand-delivered to the Speaker's office here at the Guam Congress Building. The public hearing is now adjourned. It is now 9:27. We will take a short recess and return to the public hearing on Bill number 313-36 COR at 9:30. Situas Masi.